But here in New South Wales, as Ed points out, we don't have a Bill of Rights at a provincial, at a state level. And we don't have a Bill of Rights at a federal level. And everyone thinks we have a Bill of Rights, thinks we have certain essential rights. When you tease your way through certain common law principles and the like, you will find the odd sort of difficultly stated right. As a general rule, courts have a view that when you come before them you should be given a fair trial, unless they're met by a bit of state legislation which says you don't deserve it. As a general rule, courts think that you should be heard and have a right to sort of press a case for a grievance against the state government, unless of course there's a piece of state legislation which says you can't. And there's a lot of state legislation which says you don't have certain rights, that says the state can do certain things and you have no answer to it, and that takes away a lot of these basic common law rights here in New South Wales. But I thought I might first of all talk about where we're at on a national level about Bills of Rights. Now, while we don't have one here in New South Wales, we're actually almost surrounded by Bill of Rights. So there's a little enclave of Bills of Rights in the ACT. And the ACT in 2004, after a really long consultation process, adopted the first ever Bill of Rights here in Australia. And it was one of those moments where there was a chance then after that for it to catch fire and spread across the country. But it didn't. It got a little glow. But first of all, I'll explain what the ACT Bill of Rights does. It's not a constitutionally enshrined set of rights. So it's just an act of Parliament, like any other act of Parliament. So if the next Parliament comes along and wants to change it, they can. They don't have to go back to the people through a plebiscite or a referendum. So it's an act of Parliament. That's the first thing. The second thing about the ACT Bill of Rights is that whilst it enshrines a whole series of rights, it says in relation to the great bulk of them that these are up for debate and political debate. They're not absolute. Your right to a fair trial, an absolutely fair trial, might at some point be limited by a state which has a limited amount of money to run a criminal justice system. And therefore you may have a state government that say, well, whilst in a perfectly fair world you could run your case for 4 years, we actually haven't got that amount of resources. If you run a case for 4 years, other people won't be able to have the resources to run a proper case for 6 weeks. And they put in place a whole lot of trial management laws that limit your right as a defendant to do certain things. You know, cross-examine a witness for 5 days. And they could reasonably put in some legislation that limited your perfect rights to an absolutely perfect fair trial, so as a criminal justice system worked and functioned. They might say everyone has a right to to free political speech and free political communication. But that would of course come into conflict with the road rules if you wanted to stand in the middle of Macquarie Street or stand on the middle of Brisbane Avenue in the ACT with a megaphone and insist on everybody stopping and hearing your political message. Your right to freedom of speech at that point would be reasonably constrained by the other rights that people have to get about and do their daily business. We know this as advocates of human rights, but the ACT Bill actually says it quite expressly. It says, here's a bunch of rights, but there may be circumstances when the Parliament and the people generally want to limit some rights, want to circumscribe some rights. And I think everyone would accept that. That's the role of politics in some ways, weighing up competing rights. But one of the crucial things the ACT Bill did, and it was modelled on other legislation in Canada and some European legislation, was it tried to actually put a culture of human rights right at the heart of the government. And it did it in 2 ways. First of all, it said when the government is putting a bill before the Legislative Assembly down in the ACT, whoever the minister is who's got responsibility for the bill, or if it's a private member's bill, whoever the member is who's got responsibility for the bill, had to put a statement attached to it which said whether or not it was compatible with human rights. And that meant that if, for example, a piece of legislation was going through which limited your ability to, say, consort with people who'd been convicted of a crime, then there would be a statement attached to it which said, this is not consistent with the rights to freedom of assembly, this is not consistent with the rights of people to have done a free and open criminal justice system. And these rights are constrained in a particular way. But I, as the government, think that it should be passed for the following reasons. So what it does is, when the Parliament's got a bill before it, there's also a statement there that's also tabled at the same time as the legislation goes before the Parliament in the ACT. And it's meant to engender a debate on the floor of Parliament. about why or if this constraint of someone's rights is legitimate and actually meant to happen when the bill's going through Parliament. And in a Parliament like the ACT, which tends to not be dominated by any one party, but tends to be a sort of merging series of coalitions between the Labor Party, the Liberal Party, and the smaller players in the form of the Greens, having that document which starts a debate on the floor of Parliament has actually worked in the ACT. They've actually discussed and debated on the floor of Parliament human rights. And they do it as a routine matter when they're considering legislation. And it changes the culture, the legislation-making culture in the ACT. It also changes the culture of the bureaucrats who are putting stuff up for legislation. Because let's be very clear about this. 95% of legislation isn't created in the mind of a politician or a parliamentarian. 95% of legislation starts in the mind of a public servant. And then the public servant agitates for change for a variety of reasons, or a group or an organisation advocates for change. And if they know that in the course of putting forward a bill before the Parliament, they're also going to have to attach to it a little document that says this stinks on a human rights level, that actually changes the way public servants present legislation. It changes the legislation that gets fed into the political system. And that has a real cultural change, not just in the Parliament, but for me, in many ways, given, as Ed says, just how bureaucratic and administrative most of our rights are, if it's having that conversation, that human rights conversation, at a bureaucratic level and a public servant level, before they even present the legislation to the Parliament, for me, that is probably one of the sort of benchmark achievements of the ACT Bill of Rights, because that conversation is now not just happening in Parliament, it's permeated all the way down in the levels of bureaucracy in the ACT. And then the other thing the ACT Bill of Rights does is it says, once the Bill of Rights has been passed, whenever the courts are looking at another law, not a Bill of Rights law, say for example the Crimes Act in the ACT, they are to strive to interpret each of the provisions in the Crimes Act to be consistent with human rights. So if there are two interpretations open, if a court's looking at a provision in the Crimes Act that says, on one view, might very greatly circumscribe your rights, but if you took a slightly different view of it, might not act in such a negative way, having a Bill of Rights there says the courts are, wherever possible, to choose that more open, that more human rights-based interpretation. And that has also had an impact on case law in the ACT. And again, if ultimately a court says, well, I've looked at this legislation and it's inconsistent with the Bill of Rights, and no matter how I look at it, even if I stand on my head and look at it in a bent mirror, it is still inconsistent with human rights. Well, then what the court is compelled to do is issue a statement as to incompatibility. And that statement as to incompatibility gets sent to the Attorney General, and the Attorney General has to table that in Parliament and table a response to it and say why it is reasonable to have this legislation incompatible. And that generates another debate about existing law. That's the ACT model. And I've got to say, that's the model that was then adopted in Victoria about 2 years later. And both of those governments have that kind of human rights dialogue going on now. As Ed said, it allows for people in community legal centres, ordinary citizens, to actually start that conversation, not always with the politicians, but actually start it with the departments and say, hang on, you're not living up to your human rights standards. This is incompatible with human rights, and we should go about changing your conduct. So it's not only in the Parliament, but more fundamentally permeated throughout the bureaucracy and the government itself. That's the model that when I consulted about 12 months ago, maybe a little over 12 months ago now actually, about how to take human rights forward in New South Wales, that's the model that my office decided to adopt on behalf of the Greens here in New South Wales. So not entrenching the rights in a constitution, although my goodness I'd like to get there at some point. Not putting in place an absolute set of absolute laws, but putting in place a Human Rights Act that goes about changing the culture. Let's let that operate for a decade, and once we've had a different culture, once people are actually accepting and understanding and benefiting from a human rights bill, let's take it the next step after that. Now, sometimes Greens get criticised as being as being too fervent, wanting too much early on. I actually think that this would be a great achievement, even though it's a more modest Bill of Rights, if we could get it up here in New South Wales. Are we likely to get it up in the next 3 years? I think no, we're not. This government doesn't seem to me to be one that wants to gobble up a human rights bill and deliver additional rights. But do we have to start the conversation? Do we have to start talking about rights and the benefits of human rights bill? Yes, we do. Is, I think, one of the best way of doing that, actually at some point in the next 12 months or so, presenting this legislation before the House, hopefully with a larger community campaign before that. So as we start talking about what we could do at a state level, I think that is, and that's the goal of my office. We do have some benefits at the moment in terms of having that debate. The first is we no longer have Bob Carr as the Premier. He spent the better part of a decade as the Premier of New South Wales spouting how much he hated lawyers. And wherever he possibly could, he wanted to attack lawyers and viewed them as the cause of a problem rather than the symptom of a disease. Having got rid of Bob Carr, I think is a good step forward, because Bob said it would be over his dead body that we would have a human rights bill here in New South Wales. Secondly, we've got rid of John Hatzisteros, who was the previous Attorney General for the Labor Party. John Hatzisteros said it was his worst nightmare that New South Wales adopt a Bill of Rights. And we have an attorney in the form of Greg Smith, who has never made a statement opposing a Bill of Rights. In fact, who has made statements at different points along the lines of, well, a Bill of Rights time will come, and a Bill of Rights is not a bad thing. Of course, Greg Smith sits in a cabinet which is populated by a bunch of people who I would say are, on the whole, hostile to a Bill of Rights, and that's why I don't think we will progress and get a Bill of Rights here in New South Wales with the current government. But we have an Attorney General who's not going to have that knee-jerk response and say that they are so opposed to a Bill of Rights because, in their minds, it will hand power over from the Parliament to the courts. And for them, that would be an outrageous thing. Now, I've got to say, whenever a politician stands up in front of a group and says, you don't deserve these rights or you don't need these rights, that's the sort of time where warning bells should go off. And people should be very suspicious about any politician who stands up and says, you don't need rights, you're perfectly well served by the current system. But I think we do have a political landscape here in New South Wales which is going to allow us to have that discussion about rights without being infected by the kind of negative rhetoric of previous administrations. We have a work in practice in the form of the ACT in Victoria, which we can point to and show how it does positive good things. I probably disagree with Ed on one point that he said, which is people of different classes or different structures probably don't recognise the need for a Bill of Rights and probably won't benefit from a Bill of Rights insofar as people from perhaps more marginalised groups. I think we need to break through that discussion because in some ways one of the hardest discussions about selling a Bill of Rights is the Daily Telegraph will respond by saying this is a set of rights that are going to give rights to rapists and pedophiles and who cares about them? Which is really, I think, the political rhetoric that we will inevitably get when we have a Bill of Rights. Because people see it as giving rights to people they don't like. Marginal groups, Aboriginal groups, gay people in community, people that they are ready to marginalise and call sort of outsiders, and ignoring the fact that a Bill of Rights properly put in place would in fact permeate the whole culture. Won't just put in place rights for minority groups. Of course, minority groups should have rights. We need to say a Bill of Rights will go well beyond that. Will change the culture here in New South Wales and benefit all of us equally, whilst lifting up the standards and protecting the rights of those minorities who absolutely need it here in New South Wales. I think it's afternoon tea time. Is that right, mate? Correct. Afternoon tea. And then after afternoon tea, we might come back here and have a discussion off the floor, either questions or if people want to make short statements. Okay, thank you.